Welcome to ABI Podcast. This is Melissa Jacoby. I'm the resident scholar at the ABI for spring 2016 and a law professor at the University of North Carolina at Chapel Hill. Today we're talking about the clash between bankruptcy and forfeiture actions, and I can't imagine a better guest for this discussion. It's Karen Gebbia, a professor at Golden Gate University, formerly of University of Hawaii, and she chairs the American Bar Association's Business Law Section Initiative and Working Group on Asset Forfeiture and Business Bankruptcy, and also has produced some very helpful scholarship on this subject. Welcome, Professor Gebbia.
Thank you so much, Melissa. I really appreciate the opportunity to share some information about this important issue.
Well, and we're eager to hear it. So let's start with a basic question. Just give us a brief reminder of what forfeiture law is before we get into the clash.
Okay, well, although there are different types of forfeiture, the really striking thing about forfeiture that distinguishes it from any other sanctions that could be imposed by a court or governmental agency is that forfeiture allows, and in fact usually actually requires, the government to seize assets. Often this occurs when the DOJ is pursuing a criminal action or the SEC is pursuing a securities law violation, although it's available for a variety of other state and federal agencies and a variety of other purposes. And so what happens is the government can seize not just property that has been used to facilitate a crime or a securities law violation, but also the proceeds of that crime or violation, the profits of the operation. And if none of that is available, they can go out and essentially get a money judgment and seize what's called substitute property, which basically means any property it can find. So, for example, if you had fraud that infiltrated a business operation, the forfeitable assets could constitute most or all of the business's assets, which are, of course, the same assets that the creditors would otherwise be looking to for payment.
So, yes, the clash is becoming clearer and clearer very early. So you've called fraud the deranged matchmaker between bankruptcy and forfeiture law. And I'm getting the sense that these two areas do not play well together, and maybe you can give us a sense of why that is.
Right, and I've done some writing on how this comes up in fraud in particular, but it's not limited to fraud. But the reality is that since forfeiture law was expanded to cover financial crimes such as fraud, the clash has become really dramatic. And so essentially what's going on, the reason bankruptcy and forfeiture clash is because they have different purposes. When you think about forfeiture, it came out of a system that is focused on the bad guy. Its goal is to take the ill-gotten gains and property used to facilitate crime against the bad guy. And bankruptcy is okay about not giving relief to the bad guy as well. It doesn't give the discharge or discharge fraudulently incurred debts. But the problem is, or one of the problems is that forfeiture and bankruptcy take dramatically different approaches with respect to distribution of the assets. So while bankruptcy law is trying to maximize value by having single collective enforcement proceeding, which is the classic characteristic of other insolvency proceedings such as receiverships and assignments for benefit of creditors, and then it takes that and tries to distribute it equitably, it's using a very sophisticated, detailed, statutorily prescribed priority scheme, and that scheme is taking all of the stakeholders into account, and it applies regardless of why the debtor is in bankruptcy. Forfeiture, in contrast, it did start out as a collective creditors' rights enforcement proceeding, so it actually didn't begin with any foundational principles regarding asset distribution. As it expanded, the idea of ultimately distributing some of the forfeited proceeds to victims became important, especially with the rise of the victims' rights movement and as the government began to amass literally billions of dollars worth of forfeited property. But it's not just a situation that's a turf war, either bankruptcy or forfeiture, administering the assets and making distributions. The actual substantive results in terms of how much is going to be available, who is going to receive distributions, how the distributions will be shared may vary dramatically depending on whether forfeiture is administering the assets or bankruptcy is administering the assets. And that's all further complicated by the fact that when the parties and courts try to resolve the substantive tensions, there are no procedural rules that govern the interactions between bankruptcy and forfeiture. Regarding even the most fundamental things, like can the courts talk to each other? Do the parties have to let the courts know about the parallel proceedings? Can they share evidence? Will the U.S. attorneys talk to the bankruptcy trustees, etc.? And as you indicated at the outset, 20 years ago, this didn't have a huge impact because the scope of forfeiture was much narrower. And so it only occasionally affected insolvency cases. The two main changes that have occurred, especially since around 2000, are that forfeiture now has extended to virtually all federal crimes: fraud, financial crimes, securities law violations. It's no longer limited to maritime law and drug crimes. And secondly, the scope of what can be taken is very, very broad, not just facilitating property, proceeds, substitute property, as I've mentioned, but the real bellwether is something called relation-backed doctrine. And under this theory, the title to all of the forfeited property vests in the government at the time the crime was committed. So under that theory, property that we would think is property of the bankruptcy estate never actually became property of the estate because the government's title vests back to years ago when the crime began.
So bankruptcy professionals will intuitively understand why this matters, what you've just explored, and also should be struck by that expansion of when forfeiture can arise. The challenge, of course, is making Congress care to the extent that legislative solutions are one of the ways you ultimately want to go. So tell us a little more about who the affected parties are by this lack of coordination. It may vary from case to case, but if you can give us some examples, that might be helpful.
Okay, well, in general, I would say that the most important thing to recognize that everyone from every constituency should and does recognize is that there is so much waste, increased cost, and inefficiency that comes from the fact that we have duplicate, conflicting systems. We have extensive litigation. The Rothstein case in Florida is a good example, over really fundamental